this press conference here in Carson City, our state capital, where our government convenes to tackle some of the most challenging visions of the future for our residents, our businesses, and our visitors alike. It is my pleasure to stand side by side with our esteemed guests here today, each of whom has dedicated themselves to a safer Nevada for us all. Among our guests, representing the Nevada Sheriffs and Chiefs Association, is Sheriff Richard Hickok, Churchill County Sheriff's Office, and President of the Nevada Sheriffs and Chiefs Association. Alongside Sheriff Hickok and I, Sheriff Darren Balaam from the Washoe County Sheriff's Office, Sheriff Dan Coverly from the Douglas County Sheriff's Office, and Sheriff Mike Cullen from the Story County Sheriff's Office. From our prosecuting colleagues, the esteemed Washoe County District Attorney, Mr. Chris Hicks, and his Chief Deputy District Attorney, Jenny Noble. From Carson City, District Attorney Garrett Pruitt. And from the Nevada Department of Public Safety, my friend and Director of the Department of Public Safety, George Tagliotti. Today's conference centers on Senate Bill 457, Nevada's Safe Streets and Neighborhoods Act. You'll be hearing the details of this bill from not only our governor, but from strong advocates, including the District Attorney, Chris Hicks, Director Tagliotti, and Sheriff Balaam. Following statements prepared by the governor and those esteemed gentlemen, you will be provided an opportunity to present direct questions to the presenters regarding Safe Streets and the Neighborhoods Act. Now at this time, it's my pleasure and honor to introduce our governor of the state of Nevada. Born in Japan in 1962, Mr. Lombardo moved to Las Vegas in 1976 and was educated at the University of Nevada, Las Vegas. A fellow veteran to many of us here, he served in the United States Army from 1980 to 1986 before becoming an officer with the Las Vegas Metropolitan Police Department in 1988. Capping a 34-year career in law enforcement in Clark County, Joe Lombardo served as the 17th Sheriff of the Clark County Sheriff's Office from 2015 to 2023. The governor was elected to his office, taking his seat in January 2023, becoming the 31st governor of the state of Nevada. Governor Lombardo has dedicated and esteemed career is a service to our nation and our great state. Ladies and gentlemen, please give a warm welcome to my friend, the Honorable Governor of the great state of Nevada, Joseph Joe Lombardo.
Well, thank you, Kenny. I've never had that kind of introduction. Well, welcome everybody. I appreciate you, everybody dealing with the weather and what we're trying to achieve today in this press conference. So good afternoon, and thank you for being here today as we introduce Senate Bill 457, which is my Safe Streets and Neighborhoods Act. But before I get started, once again, I want to thank Kenny Furlong and his hospitality and bringing together all the important individuals involved in law enforcement to address a particular issue that's of importance to everybody in every community across our great state, and that's safety and how we deal with safety into the future. And additionally, I want to recognize some of our legislators here in the audience, one of them being Lisa Cole, Assembly Member, Assemblywoman. Ken Gray, thank you for being here. Brian Hibbets, Greg Hafen, thank you for being here today. I appreciate your support. And Kenny did the great effort of introducing everybody, so I will not repeat that. But I think it's important for me to recognize how much I value your insight and your participation in the law enforcement community and participating in the joint committee that we put together in order to address the particular issues we deal with on a daily basis in both the law enforcement and the judiciary and the prosecution of criminal activity. And Kenny was a little quick to introduce Ms. Noble. And I think it's important that she has due recognition for all the efforts she's done in the past session and this session on the language. So raise your hand real quick so the press knows who you are. on all the language that we've put into the bills. And so hopefully we'll have this bill meet with the same success we did in the last session. So thank you, Jennifer. So last session, I introduced and signed my first piece of public safety legislation, the Crime Reduction Act. The Crime Reduction Act cracked down on our most egregious offenders by increasing penalties on drug dealers, limiting early discharge from probation for gun violations and home invasions, and fighting the fentanyl epidemic. However, it's evident that more work remains in our fight to secure our communities, which is why I'm proud to introduce the Safe Streets and Neighborhoods Act today. This legislation was drafted to put teeth back into Nevada's penal code, hold criminals accountable, empower judges and prosecutors, and support victims of crime. You know, and I think that paragraph does repeating because it's the whole key and the crux and the foundation of this bill. This legislation was drafted to put teeth back into the Nevada's penal code, hold criminals accountable, empower judges and prosecutors, and support victims of crime. This bill is extensive, but I'd like to share a few highlights of the bill with you today. First, the Safe Streets and Neighborhoods Act enacts tougher penalties for theft, burglary, and for repeat offenders, which Sheriff Balin will discuss further as we move into the process. The Safe Streets and Neighborhood Act also cracks down on fentanyl and drug trafficking. In alignment with my commitment to combat the opioid crisis, the bill introduces harsher sentencing for fentanyl, including mandatory minimums and increased penalties for large quantities. The bill implements a stronger protections for vulnerable populations by eliminating diversion programs for crimes involving an abuse or exploitation of children and elderly or vulnerable adults, ensuring justice for Nevada's most at-risk populations. The bill restores judicial discretion and revises access for sealed records, which allows our state to prioritize public safety and accountability in our judicial system, in particular to criminal enhancement and firearm background checks. The bill holds violent offenders and repeat DUI offenders accountable, as Director Tagliati will discuss here shortly. Before turning it over to Washoe County District Attorney Chris Hicks to discuss portions of the bill, I'll say this. As a law enforcement officer for 34 years and former sheriff, I've seen public safety legislation impact our communities and neighborhoods firsthand, both for the better and for the worse. As governor, it's now my responsibility to pass legislation that makes our streets safer and our communities more secure. Historically, partisanship has prevented meaningful progress for public safety, but I am hopeful we can push past that this session. For the good of Nevada families and for the good of their own communities, it's my hope that legislators will partner with me on this bipartisan bill. With that, Chris, can I call you forward? Come forward, sir. Thank you.
Well, good afternoon. On behalf of the Nevada District Attorneys Association, we are grateful to Governor Lombardo for bringing together this broad coalition of victim advocates, business owners, prosecutors, and law enforcement leaders. Our task was to identify common sense criminal justice reforms needed in Nevada that will protect victims of crime and improve the safety of our communities. The result is SB 457. And as Washoe County's District Attorney and the President of the Nevada District Attorneys Association, I speak for all our great state's elected district attorneys and prosecutors when I say thank you to the Governor and his staff for working with us. This bill is a positive step forward in addressing the safety concerns faced by Nevadans every day. I'm going to give a brief overview of some of the key components of the bill. Section 1 touches on the enhancement, or gives an enhancement for new felony offenses committed during felony pretrial release, when someone's out on bail. When people charged with a felony commit a new felony while out on bail or pretrial release, they demonstrate a disregard for the law and a continuing threat to the community. the governor's bill holds felony defendants accountable for new felonies committed while awaiting trial by creating a sentencing enhancement that applies to the new felony. Section 2 addresses stalking and cyberstalking. This section strengthens Nevada's stalking laws by further addressing the dynamics of this crime and how it occurs in the 21st century. The bill recognizes that stalkers often seek to terrorize their victims through other members of their household or family or someone who they're having a dating relationship with. It empowers prosecutors and law enforcement to hold them accountable. It also addresses stalking that occurs through social media and other electronic means. Section 3 applies to possession of child pornography. Under current law, pedophiles can possess numerous images of children being sexually abused, but can only be held accountable for a single count of possession of child pornography. 100 images, 1 count. 1,000 images, just 1 count. Each of these images represents a separate trauma to these children. The bill holds these criminals appropriately accountable by enabling prosecutors to charge a separate felony for each child sexual abuse image. Section 4 ensures that domestic batterers and felons surrender their firearms. Nevada law requires courts to order convicted domestic batterers to surrender their firearms. Courts may also issue similar orders when a person is subject to an extended protection order or as a condition of pretrial release. To ensure safety of the community and crime victims, the bill requires that courts hold a compliance hearing within 2 to 5 days to make sure that these orders are being followed. Section 6 addresses our retail theft issues and provides for an enhancement with third-time theft offenses. Under our current law, thieves can repeatedly steal up to $1,200 and only be charged with a series of misdemeanors. This hurts Nevada businesses and in turn Nevada consumers. The bill allows prosecutors to file felony charges if a defendant has 2 or more prior theft convictions. Section 7 increases the penalty for burglary of a business, structure or motor vehicle. Burglaries can have a devastating impact on people and businesses, particularly for those who are struggling to make ends meet. Previously, Nevada punished all types of burglary as just a Category B felony. In 2019, the crime of burglary was separated into 3 categories: vehicle burglary, burglary of a business, and burglary of a structure. The penalties were significantly reduced. This bill retains those 3 categories but increases the punishments. Section 10 through several other sections, I won't name them all, reduces the felony theft threshold to $750. Again, this will help with our retail theft issues. In 2019, the legislature nearly doubled the amount needed for a theft to qualify as a felony. It went from $650 to $1,200, $250 more than California. The change has had a significant impact on retailers and ultimately on consumers. Career thieves have been empowered to steal more and avoid consequences. For example, in Washoe County, theft calls for service at the Legends outlets in Sparks, which consists of 37 stores, has increased by 248% from 2022 to 2024. Section 29 addresses the habitual criminal enhancement. In 2019, the legislature broadened diversion eligibility for many felony crimes, giving offenders ample access to specialty court programs to address their addictions and mental health concerns. For offenders who choose to take this opportunity, these programs operate to dismiss and seal their felony convictions. Career criminals who commit very serious felony offenses or squander these opportunities of diversion and probation must not be allowed to repeatedly victimize Nevada communities without consequence. Section 32 adds robbery, kidnapping, and attempt offenses to what constitutes domestic violence. Section 35 and 37 apply to juvenile justice. Teachers, school employees, and students deserve to work and learn in a safe environment. In 2023, there were 6,800 violent incidents in Clark County schools within a 7-month period. That same year, there were 7,400 violent incidents reported in Washoe County schools. The bill helps ensure that this unacceptable violence is adequately addressed by our system. It provides when a student assaults or batters a school employee, juvenile courts must ensure that the student is evaluated before they can return to the community. Section 42 through 49, as the governor touched upon, eliminates the specialty court diversion option for those criminals who abuse, exploit, neglect children or the elderly. Right now, criminals who victimize children and the elderly are eligible for diversion programs that offer dismissal and automatic sealing of their convictions. Future employees will have no way of knowing this history. The governor's bill eliminates this eligibility to help ensure these criminals cannot gain further access to our most vulnerable Nevadans. Section 53 extends time for pretrial release hearings to 72 hours, bail hearings. In 2021, the legislature passed AB 424, which mandated that all pretrial release hearings be held 48 hours after a person is taken into custody, with no exception for weekends or court holidays. Since implementation, most jurisdictions have struggled to comply with this reduced time frame, which is often too short to ensure that judges have all the information they need to make fully informed decisions about what pretrial release conditions are necessary to protect the public. It also will provide victims with less opportunity to be heard at pretrial release hearings. Section 56 prohibits the exoneration of bail until restitution is paid to a victim. Following the passage of Marsy's Law, the Nevada Constitution requires that any payments collected from a criminal defendant be first applied to pay restitution to the victim. The bill requires that any money collected from the defendant be first used to satisfy restitution before it can be applied to court fines and fees. Section 73 sets lower fentanyl trafficking levels. Our criminal laws must better reflect the deadly nature of this drug and hold those who prey upon people struggling with opioid addiction. 2 milligrams of fentanyl can be a lethal dose. Right now, a person can possess up to 28 grams or 14,000 lethal doses before they can even be charged with a low-level fentanyl trafficking. Section 73 reduces those thresholds. Lastly, Section 77 and several others apply to DUI reform. In 2024, 412 people died as a result of deadly crashes on Nevada roads. The leading cause of crashes were speeding and impaired driving. The governor's bill makes several changes to our DUI statutes. It ensures that when a felony DUI offender who is in a diversion program chooses to drive impaired again, they will be subject to another felony charge. It increases the penalty range for DUI causing substantial bodily harm to 2 to 20 years. It increases the penalty range for DUI causing death to 5 to 25 years. And in certain DUI fatality cases where the facts show extreme and conscious disregard for human life, the bill allows drivers to be charged with second-degree murder. Before I turn it over to Director Togliatti, I would just like to make one final point. This week is National Victims of Crime Week, and there is no better time that this bill could have been dropped. And Governor, I thank you again. The provisions within this bill will directly help victims of crime in our state. Thank you, Director Togliatti.
Good afternoon. Over the past several years, Nevada has seen a devastating trend, and that is fatalities on our roads. They're on the rise, and nearly 400 lives end each year due to fatal accidents. Last year was tragically the deadliest year in this decade, with 419 deaths on our roads. And there are thousands of individuals who suffer life-changing injuries due to road crashes. These are needless, senseless losses to our community. These are just statistics, but the real truth is families, friends, neighbors, and loved ones are forever impacted by these preventable incidents. Impairment and speed are the primary causes of fatal crashes. Choices are made by individuals who decide to drive impaired or who choose to endanger everyone with risky driving. It's unacceptable to our officers and our troopers, and it's certainly unacceptable to all Nevadans. In 2023, 2 state troopers' lives were taken because of an impaired driver while they were on duty assisting another motorist. This is not just a law enforcement issue. This is everyone's issue. We take it personally, and we take it very seriously. Alarmingly, there are thousands of DUI arrests made every year, with hundreds of repeat offenders making the same risky decisions and choices to get behind the wheel. It's time to rethink our approach to eliminating impaired driving on our roadways, which is Governor Lombardo's introducing Senate Bill 457, the Nevada Safe Streets and Neighborhood Act. This act enacts unprecedented, stringent anti-DUI measures which will help keep us and our communities safe and secure. Senate Bill 457 creates a higher level of criminal offense for DUI resulting in death and allows prosecutors to charge second-degree murder in cases of implied malice. This act also ensures presumptive thresholds for marijuana for all DUI offenses, and it creates a new enhancement for a subsequent DUI offense while the individual is also under treatment for a prior offense. It's time to change how we hold individuals accountable who make these wrong decisions. The Nevada Department of Public Safety, along with Governor Lombardo and other Nevada law enforcement agencies, are eager for this bill to be heard. Governor Lombardo's Safe Streets and Neighborhoods Act will help save lives on Nevada roads. I want to thank you, and I want to pass it over to my colleague and the Washoe County Sheriff, Darren Bailey. Hey, George. Sorry.
Good afternoon, everybody. It's my honor to speak today, and first of all, I want to thank Governor Lombardo for allowing me to participate on this committee. And I would say not only does this bill protect those victims, but it also keeps our neighborhoods and state safe. And you've heard about the penalties and the enhancements of some of the crimes that this bill addressed, but today I'm going to talk about something more important for those that are suffering from opioid use disorders and how this bill will help those get onto the road to sobriety. You see, the portion of this bill focuses on enhancing public safety through several key changes, including revising provisions addressing opioid use disorders, as well as how the Fund for a Resilient Nevada allocates money for training for law enforcement, governmental agencies, and the rest of the criminal justice system. Section 61 and 62 of this bill requires those who establish medication-assisted treatment, or MAT programs, and substance use disorder programs to collaborate with the Department of Health and Human Services. Besides the Department of Corrections, for sheriffs, chiefs, and town marshals, it delineates that they must establish a MAT program for those offenders that are suffering from substance use disorders subject to available funding. It also provides that these programs, while offender is incarcerated, they must be provided the MAT program their entire duration of the incarceration. And that all decisions for the dosage and the duration of the medication are made jointly by the treating physician and the offender, so the offender has the ability to control how they're moving along on their road to sobriety. Section 65 outlines the statutes that provides for the meaning of what MAT is. Section 66 of of the bill states that the department shall make available on their internet website and maintained by the Department of Correction information related to peer recovery services and how individuals can access those services. 69 outlines a report to be compiled by the Advisory Committee on Resilient Nevada, and Sections 70 through 72 mandates the fund for Resilient Nevada to be used for training law enforcement and criminal justice agencies in trauma-informed practices and MAP programs for opioid use disorder. Now let me talk about the MAP program and what we've seen so far. In 2019, the Washington County Sheriff's Office obtained our certification for our opioid treatment program as well as our medication-assisted treatment program in the fall of 19. Since that time, 793 inmates have come through our facility and have been served by that MAP program. In 2021, we were the first to work with the Department of Corrections, and we sent our first inmate who actually volunteered to stay longer in our facility to get onto the MAP program and to be transferred to the Department of Corrections. And we've checked up on that inmate, and she continues down the road to sobriety. In 2024, let me give you some other numbers. We had 21 individuals booked into our facility that had an opioid use disorder, and we were inducted into our MAP program, so they started the MAP program. Only 5 recidivated within that year. We had 209 individuals who were on a MAP program in our community, and for one reason or another, they found themselves incarcerated in our facility, and we were able to, because of the certification, continue them on their MAP program, and only 41 of them, or 1 in 5, recidivated in 1 year. In 2025, in just 3 months, we've had 8 individuals inducted into our program, and we've had another 98 being booked into our program that were on a MAP program that are currently being served by our MAP program. And what does this say? We're seeing results, but more importantly, we're seeing success of the MAP program. So not only are we enhancing those penalties and protecting our victims, but this bill also provides for those that have that addiction to go onto the road to sobriety. And by moving to enhance the availability of these types of programs and increasing the number of people participating in the programs in NDOC, as well as continuing partnering with the Department of Health and Human Services, I am confident that we will not only see these results, but we will see continued success for those suffering from opioid use disorders. And with that, I'll turn it over to Governor Lombardo and DA Hicks for any questions.
Thank you. All right, we have the opportunity for a little Q&A, so go ahead, Ben.
Yes, Governor, you mentioned that it was a bipartisan bill. Are there Democratic lawmakers in the legislature that support this, or?
Well, I can't speak to the individual names, but they were part of the working group establishing these guidelines and foundation of the law.
There are Democratic lawmakers
Yes.
that are voting to support this?
Well, not the, you said as is at the end of your statement. Obviously, you know how a bill goes through the process, right? We'll get an introduction, we'll have work session, and is it open to amendment? Yeah, because that's just part of the government process, a consensus at the end.
Where will the money to fund beef up funding for the Nevada Department of Corrections come for this? Because it's estimated this will create hundreds of new inmates.
Right. I appreciate you asking that question. It's no secret. It's been in the press here recently, the budget issues associated with the Department of Corrections. There has been some mechanisms to address those budget issues. But more importantly, some of those issues were a result of decisions that came out of the legislature, and that's mandatory post assignments within the jail environment, which is appropriate because it creates an environment of safety both for the employees and the inmates. But we are currently evaluating time served for non-violent offenses. We'll make an adjustment in the budget numbers that go into the future sentencing and removal of individuals from the incarceration environment. And then additionally, we will work through the existing bills that are going through the state process that we can balance the budget with. To address this. In my level of importance and triage of what we deal with in state government, nothing is as important as you can experience through law enforcement.
The amendment process, you mentioned that. Are there red lines that you will not accept, that you will not throw?
Yeah, of course there is, but I'm not at liberty to say. here. It's all matter of discussion and consensus and conflict that occurs in the government process.
And so, Governor, last session there was another bill similar to yours surrounded with the fentanyl, kind of about the same number with those trafficking numbers. Wasn't as well received last session to get those approved. I guess, what do you think will be different going around?
Well, we continue to see the scourge of fentanyl, right? Both in the addiction and the trafficking space, and the detriment to our communities. And more data was needed in order to promote what I attempted to achieve in the last session. We have more data that addresses the particular issue associated with fentanyl, and hopefully it'll meet with a positive response this time. Now, I don't want to downgrade what occurred last session. We made some improvement in that space, but I think we need to go a little bit further with a better understanding exactly what the drug does to our communities. All right, I thank you for your time. I appreciate everybody. Oh, go ahead.
Yeah, I have two other questions for you. So given that, addressing time for nonviolent crimes may be a mechanism to address some of the Department of Corrections' current budget shortfalls, how do you anticipate that squaring with your proposal, given the felony theft threshold, that might actually increase that nonviolent criminal population?
Well, it's all a matter of balancing the budget, correct? And like I said, it's the utmost importance to me to ensure that the law enforcement community has the tools in order to change the crime picture in our communities. And we will figure out a way through the government processes and all the available funding resources available to us to address those particular issues. And that's not a number that can be just dismissed as associated with a nonviolent criminal act and the time served. We're projecting in the first year we could save approximately $37 million on that particular community within the jail environment. So as you get into a biennium, you double that, and then you compare it into the projections for the felony crimes. So one of the things that was addressed in this bill in its infancy, and I'm sure it's going to be adjusted in the work session, is the number of violations for habitual offenders. Currently, it's 7 or more of similarly situated felonies. The proposal was 2 to 3 violations, and the happy medium there would be 3 to 5. 1, to change behavior, and 2, to control the costs that go along with it.
Great, thank you. And I'm curious if there's, given some of the federal funding uncertainty around opioid treatment, if that can call into question some of the substance abuse treatment programs.
Yeah, absolutely it will. I mean, this is an expansion of the use of those funds that Sheriff Balin described, and he professed to the success of those programs. And we would love to make it a statewide issue/solution. It's very frustrating when you have your major urban areas that have the concentration of support. As you can see by the sheriffs that are here, it's inclusive of all our rural areas, and we have to ensure that we expand upon all those programs for the success of the entire state. And yes, it would be a detriment if we were to lose availability to those programs, but we quite often we deal with adversity in the state of Nevada very eloquently and very successfully, and we'll find different ways of doing business.
Great, thank you so much.
Just to circle back at the end here, Governor, do you believe that there's enough money within the current budget as it stands to fund this entire bill?
No, not as it stands, but that's why we go through budget meetings and budget hearings and processes. So when we go through the state process, it's a matter of priority for both my office and the legislature. So, ma'am, one more question.
I was just wondering, so last session there were some concerns. So in addition to needing more data, and in addition to having some some concern about the number, what were the other pushbacks or the other concerns regarding this bill?
Well, quantitative and qualitative analysis through the lab environment. What we're experiencing in the criminal element is what we call mollies, or multi classes of drugs compounded together, and you have to differentiate between Schedule 1, 2, and 3 and the amounts that go with the different trafficking levels. So the evaluation of that has been limited because of the science associated with it. So,
Thank you. Thank you, everybody.
thank you. Thank you.